Good morning or good afternoon, depending on where you are. Thank you all for joining us today for the laws and regulations of commercial driver licensing. My name is Jenna Howell. I am General Counsel for the Department of Public Safety here in Pierre. And driver licensing is not only one of the agencies I represent on behalf of the department, but it's also within my division. So it's something I've been working on and with for about 8 years now. And there are a lot of questions that I get regarding particularly commercial driver's licenses, but also some other just regular driver licensing information that I hoped it would be helpful to share with all of you. If you're connected through the chat function on your screen, you can ask questions throughout. Nicole is going to help me with those. I can try to answer them as they come in, or else there will definitely be time at the end of the presentation to go through all of those. One of the things that I just wanted to start out with at the beginning is some acronyms. And I apologize, I realized that I have used them in the slides and I will probably use them just out of habit as I go through. So a CDL is a commercial driver's license. A CMV is a commercial motor vehicle, and a CLP is a commercial learner's permit. So those are generally the big ones. I'll be glad to repeat that at any time or provide it to you guys offline as well. So then the next big acronym, and the second slide in the presentation talks about Okay, there we go. So FMCSA, that is the Federal Motor Carrier Safety Administration, which is part of the Federal Department of Transportation. Commercial driver's licenses are regulated entirely by the federal government under the authority of the Interstate Commerce Clause. Well, I shouldn't say entirely. There are some intrastate CDLs that the federal government doesn't get involved with, but for the most part, it's all regulated by the federal government, and the regulations are found in Title 49 of the CFR, and I'll be referencing some specifics of those as we go through. But the state's authority and the department's authority through driver licensing is all derived from the federal government and overseen by FMCSA. A lot of the regulations in CFR have been adopted by our code. I've provided some of the statutes that just adopt entire sections of the CFR, but also throughout our code, our legislature has adopted some of the same statutes verbatim in their own sections. One example, which we'll get to in a bit, is the anti-masking statute in 3212A64. That is in the rules, it's adopted in 3212A58, but it's also written out as its own statute. So the authorities come both from state law and federal regulation and are often duplicated throughout our code. 3212A is our state's commercial driver licensing chapter. 3212 is the general driver licensing chapter, and they do sometimes cover some of the same issues. In 3212A2, it provides that 12A, which is the commercial driver licensing chapter, controls, as far as commercial drivers, over the general provisions in 3212. But where there is no provision in 3212A, where there's nothing specific to commercial drivers, then 3212, the general chapter, controls. Some requirements that belong to the state under the federal requirements is that we are required to disqualify commercial driver's licenses and commercial driving privileges for all required offenses. Those offenses are generally listed in 3212A through 36 through 38, and then in 12A 40 and 41. There is a difference between disqualifying a license and disqualifying a privilege. Most frequently, it's the difference between in-state and out-of-state drivers. If you have someone who holds a South Dakota commercial license and they commit one of these disqualifying offenses, then we will disqualify them. We will actually disqualify their license. If, however, they're actually licensed in, say, Texas, and they get a disqualifying offense in South Dakota, we will disqualify their privilege to drive in South Dakota because we don't actually have the authority to disqualify their Texas commercial license. Occasionally, it's also we will disqualify a privilege if you have somebody who doesn't actually have a license, even if they are a South Dakota resident. For example, someone who's driving a commercial motor vehicle while they just have a commercial learner's permit, or might be driving a commercial motor vehicle and they don't have a CDL or a CLP at all. In those cases, we disqualify the privilege. So you'll see that language throughout the chapter, and that's generally the differentiation. 7 of the most important disqualifying offenses are found in 3212A36. And I'm not going to go through every offense, but I just wanted to run through a list of some of the most frequent ones and also some of the most severe. Those are driving under the influence, which is irregular, the .08 or under the influence offenses from 3223. .04 DUI, which is specific to CDLs, and we'll talk about that shortly. Leaving the scene of an accident, using a commercial motor vehicle in the commission of a felony, refusing a chemical analysis, driving a commercial motor vehicle while suspended, revoked, canceled, or disqualified, or negligently causing a fatality with a commercial motor vehicle. If you get one of those offenses, you're required to be disqualified for a minimum of 1 year. If you get 2 or more of those offenses, there is a lifetime disqualification under SDCL 3212A37. And then if you are convicted of using a CMV to manufacture, distribute, dispense, or having possession with intent while in a CMV, that is a lifetime disqualification under SDCL 3212A38. Those of you who are familiar with this probably know that lifetime disqualification does not always mean lifetime disqualification. Under SDCL 3212A39, the department has the rulemaking authority to allow some individuals to get their licenses back after 10 years of receiving a lifetime disqualification. That is Administrative Rule 61250301, and that rule provides that if you receive a lifetime disqualification for any of the combination of offenses in 3212A36, which are the 7 I just went through, that lifetime disqualification is only actually for 10 years. However, if there is a conviction for the drug offenses, in a CMV under 3212A38, that is a lifetime offense, and that will not be reduced to the 10 years. The serious traffic offenses, there are 14 of those. Those are listed in the definition section of 3212A1 in subsection 31. And this is what we see most frequently. Speeding 15 miles or more over the limit, reckless driving, careless, improper, erratic lane change, following too closely, traffic control violations, failure to stop or yield, failure to stop or slow for school bus, eluding police, improper overtaking or passing, driving without your CDL or a CLP or the proper endorsement, texting while driving a commercial vehicle, or utilizing a handheld phone while driving a commercial vehicle. If you get 2 of any of those offenses within 3 years, there's a minimum 60-day disqualification. That's in 3212A40. If you get 3 in 3 years, that's a minimum 120-day disqualification. And those can occur in a CMV or a non-commercial motor vehicle if one of the offenses results either in the revocation, suspension, or cancellation of a commercial or non-commercial license, and that's found in 3212A41. So that's a lot of detail all at once, but I wanted to let you know, kind of give you the overlay of what the federal government expects of the department and how they interpret our statutes. The federal government takes this very seriously. The driver licensing program is audited annually for any to make sure we're complying with all the requirements, not just the statutory disqualifications, but the record keeping, communications, everything that falls under FMCSA. In 2018, I wanted to share this with everyone. We actually got a finding because we did not disqualify a commercial license holder after he'd been convicted of, I believe it was a drug offense in a commercial motor vehicle. And what happened, I don't actually know the case, but this is kind of what I've been told throughout the audit process, is the individual was stopped in a commercial motor vehicle, received a ticket for drug use. I don't know if it was possession or transportation. And it was marked on the ticket that the driver was a CDL holder in a commercial motor vehicle. However, the prosecutor then dismissed the ticket and issued a superseding charging document. And in that document just forgot to include that it was a commercial driver's license holder in a commercial vehicle. So that went all the way through UJS, and UJS wasn't triggered to send the conviction to driver licensing, so that individual didn't their CDL wasn't disqualified. It was eventually when FMCSA caught it and told driver licensing about it. But the program got a finding for that because FMCSA views the state as a whole, not just the program, but the judiciary, the legislature, all of it falls under the requirements for the state. So actually one of this, we had already talked about doing this law for lunch class, but we're now actually using this as part of our educational efforts to remediate this finding, because the consequences for findings in an audit can be very serious. The main three are that we lose highway funding. You lose a certain percentage the first year, and then if you're still out of compliance, you lose a higher percentage the second year. The numbers I got from DOT in the 2019 session were that these numbers would be roughly $11 to $22 million per year in highway funds that the state would lose if we have an unsatisfied finding in the driver licensing program. These funds, once they are taken away from the state, are permanently reallocated to other states or projects, so we can never get them back even if we do come into compliance. If anyone's interested in double checking, that's in 49 CFR 384, sections 401 and 403. And then thirdly, we lose the inability to issue CDLs in South Dakota, and that's in 49 CFR 384, 405. That's obviously really difficult for so many people in our state who drive professionally for a living. And obviously $11 to $22 million per year would cause serious issues, not only for our citizens, but our local governments and the state in trying to keep our infrastructure up to snuff. So like I said, FMCSA takes this very seriously. We take it very seriously, and that is why we try to be extremely diligent in carrying out all of these requirements. Again, the CFRs that lay out all of these penalties and requirements are adopted in the code in 3212A58. So just to go through what driver licensing does in a normal case. Again, if the charging sheet, the ticket, a complaint, and in any case shows that the driver or the defendant had a commercial driver's license or a commercial motor vehicle, UJS sends the conviction to driver licensing. We'll review it. If it's a disqualifiable offense, we'll proceed. If not, nothing happens with it. It does not matter if the defendant receives a suspended imposition of sentence. We'll talk about that specifically here in a bit. But then, again, if it is a disqualifying offense, driver licensing will send a notice to the licensee, and they have 15 days from the date of the notice to request an administrative hearing as to whether or not the state has the authority to disqualify their commercial driver's license or privilege. Driver licensing uses the Office of Hearing Examiners to do our hearings. We held them almost all telephonically. Occasionally somebody requests an in-person hearing, which is fine. But since most of these are spread throughout the state and it's a long trip to Pierre, we make that accessible to everyone. Hearing examiners will issue a written recommended decision to driver licensing, which driver licensing then accepts, rejects, or modifies. And as the statutory authority, driver licensing will, or the Department of Public Safety actually will issue the final decision. That's then sent certified mail and is effective 10 days from the date of delivery. I've included all of the statutory citations that outline that process in the slide, but it's the same as any other administrative proceeding under 126. The final decisions that are issued by driver licensing are obviously appealable to circuit court and venued either here in Hughes County or in the county of the appellant's residence. And then, of course, that can also be appealed up to the Supreme Court. Driving under the influence is obviously one of the most frequent, unfortunately, infractions that we see both in commercial and non-commercial driver licensing situations. This is one of two areas that still has implied consent. So there's been some revisions of that in the last 3-4 years since the Missouri versus McNeely U.S. Supreme Court decision came out. So I just wanted to clarify that requirement is in 3212A46. And for 1 year, I believe it was from 15 to 16, the implied consent statute said that if a driver refused consent, then no analysis would be done. That statute was changed a year later, and it now reads that if a person does not consent, no analysis will be done, no sample will be taken, either blood or urine, unless a warrant is obtained. So in most cases, it's my understanding that if an individual does refuse, law enforcement then just proceeds with getting a warrant and obtains the blood or urine sample that way. However, the refusal in and of itself is a 1-year disqualifiable offense under the code. There is also zero tolerance DUI that still falls under implied consent, but we'll talk about that in a bit. There is a lower blood alcohol content standard for administrative and criminal purposes for CDL holders that I wanted to make everyone aware of. Under 3212A43, if there is any measurable or detectable amount of alcohol in the driver's system, or if they refuse, they're immediately placed out of service, which is an administrative process, which just means they can't drive. It's the same as if they've exceeded their hours of service, have been driving too long in one stretch. However, under 3212A44, if they have a .04 or higher BAC while driving a commercial motor vehicle, that is a crime. It's a Class 2 misdemeanor. So that is different, and they have a higher standard, albeit a lower BAC content standard than the regular .08 or driving under the influence standard for non-commercial drivers. The most recent driver licensing Supreme Court case we had came down in 2017. It was Department of Public Safety versus Erickson. The decision that was actually issued by the court in that case centered on whether or not a .08 pleading versus a driving under the influence pleading, if one or the other triggers or doesn't trigger, as the case was, driver licensing authority to disqualify a CDL holder. What had happened was there was some confusion in the paperwork as the case went through as to whether or not the defendant, Mr. Erickson, had pled to .08 or if he had pled under the influence, and whether or not that made a difference in the subsequent administrative proceedings by the department. The Supreme Court ruled that they're really one and the same, and it doesn't matter. Driver licensing has the authority to disqualify a commercial CDL holder for DUI. In this slide, I have just provided, again, some lists of the more general sections. A lot of these have a lot of subsections. They can be fairly complicated. They involve both criminal and, again, just those administrative out-of-service proceedings, but I just wanted everyone to have that list as a starting point for your review. Another resource that I wanted to provide, and the link is on here to a PDF, comes actually from the National Judicial College, and they put together a CDL disqualification bench card. This is meant to be a cheat sheet for judges so that they can quickly look at the offense and see what is required to be a disqualifying offense. Obviously, FMCSA wanted us to share this with all of you as a handy tool for you as you're working with your clients to see what the CDL ramifications are of any given conviction. We've been talking mostly about in-state drivers because that's obviously the bulk of what South Dakota driver licensing does. But we do obviously get convictions for out-of-state drivers. And in those, our process for those situations is we get the conviction from UJS and we send it, driver licensing sends it to the home state. If we're required under 3212A42, we will also disqualify, revoke, or suspend depending on what the conviction is here in South Dakota. The reverse is also true. If we have a South Dakota driver who is convicted of something in Arizona, Arizona will send South Dakota the conviction, and then we will proceed with disqualifying, revoking, or suspending the South Dakota driver's license. So getting to what is probably one of the most confusing sections of this are suspended impositions. Yes, we fully acknowledge the suspended imposition provisions that say, you get one misdemeanor, one felony. If you haven't had it before that, then it's gone. It's off your record. You don't have to say that it ever happened or existed. However, CDLs are an exception to that. The anti-masking statute in 3212A64 specifically prohibits us allowing a suspended imposition to keep a commercial driver's conviction off their record. I've put almost the entire statute here. It says the state must not mask, defer imposition of judgment, or allow an individual to enter into a diversion program that would prevent a CDL driver's conviction for any violation in any type of motor vehicle of state or local traffic control laws, except parking, from appearing on the driver's record. And you'll see at the top of that slide that this is one of those sections where it's spelled out in the federal regulations and also adopted specifically in state law. It is driver licensing's position that 3212A64 is not in conflict with the suspended imposition statute. It is merely another exception to it. The suspended imposition statute sections have exceptions for teachers, lottery, things that can't be expunged and have to be tracked for particular purposes. We think that all of the statutes can be read harmoniously by interpreting it to be the same. Another important aspect of this analysis, though, is that the definition of conviction for commercial driver's licenses is actually, or license holders, is actually different. In 3212A1 sub 7, again, in the chapter specifically applicable to commercial driving, there is its own definition of conviction. And I've listed out most of the subsections here, but the important part is at the end, regardless of whether or not the penalty is rebated, suspended, or probated. So that, again, plays into the fact that even if you get a suspended imposition of sentence, frequently DUI is a common one, driver licensing will not take away your underlying license because that is suspended. But as far as a CDL license or privilege, that would be disqualified for a year, and that would remain on the driver's record to show that that had occurred. I have attached here another resource that we got from the federal government, and this comes from the National District Attorneys Association. And this is a masking quick reference guide. One of FMCSA's concerns and a long conversation that I had with our auditors during this year's audit involves the plea deals. FMCSA is very concerned that masking is taking place even prior to conviction by individuals pleading down disqualifiable offenses to non-disqualifiable offenses. It has long been my position that I am not the prosecutor. They're elected and they have their professional responsibilities. And if they don't think that the evidence supports a higher charge, then is obviously within their purview and their discretion to plead to a lower charge. However, I include this and just make a point of that because FMCSA is concerned and does look at masking from all of these aspects. There's also the aspect of whether or not judges can actually give suspended impositions of sentence and whether or not that in and of itself is masking in violation of the federal regulations that would constitute a finding against the program. But we have always been able to alleviate that if there is that confusion there by keeping the disqualification and the conviction on the record for commercial license holders. One last thing regarding specifically commercial commercial licenses is work permits. We will get requests for someone who's been disqualified and say, well, that's fine, but can I get a work permit? There are no commercial work permits. They're not provided for anywhere in statute, so that's just our default position. I did want to take a few minutes though now and kind of switch to some non-commercial driver licensing subjects that come up frequently. And one of those is non-commercial work permits. And so I've provided that information on this slide as well. They cannot be given to anyone who is convicted while holding a permit. Most frequently, this is underage minors who have a learner's permit or a restricted minor's permit and then commit a traffic offense that requires suspension. General rule is you already had a permit, you lost it, so we can't give you another one under administrative rule. Driver licensing cannot issue a work permit if a South Dakota court has jurisdiction, and the administrative rule is listed there. However, the program can issue work permits for out-of-state convictions for South Dakota drivers. So if you have a South Dakota driver who's convicted of, say, DUI in Iowa, and they lose their South Dakota license for that required amount of time, the program can administratively issue a work permit since there's no South Dakota court, that would have jurisdiction. Non-commercial DUI. One of the major questions and situations that we run into in this area is the administrative disqualification and the length depending on the number of DUIs. Under the code, there's a 10-year look-back period. And where this comes and becomes important is people will plead multiple times to DUI first. However, 321252.1 says that the department suspends the license based on the number of convictions showing in driver licensing record. So the fact that the conviction comes over as a first doesn't matter if there's already a DUI first within the last 10 years on their driving record. That becomes a DUI second, and the suspension period goes from 30 days to 1 year. I've provided a list of Supreme Court cases that deal with this and a few other tangential issues. Fisher is the one that is most cited, the 1986 case. Factually there, he had 2 DUI first convictions within 1 year. And driver licensing, again, issued a 1-year suspension rather than 30 days for the second DUI first, and the Supreme Court upheld that. In Moz, he got a DUI first, one in 1993 and then another in 2001. Now, in both 3212 and 3212A, there are 4-year look-back statutes for suspension and revocation. It says the program director or the secretary cannot look at anything older than 4 years under those statutes. But there is a specific statute in the DUI chapters, 3223 4.1, that has this 10-year look-back period specifically for driving under the influence convictions, and the Supreme Court upheld that 10-year look-back in that case. Steele involved an out-of-state DUI. It was actually in Wyoming in 1982, and then another DUI first conviction in South Dakota in 1985. The issue there actually wasn't whether or not it was a DUI first or a second, but the validity of the Wyoming abstract, because all that driver licensing had from Wyoming was just like a one-sheet abstract from Wyoming saying he'd been convicted of DUI. And Steele argued that that was insufficient to show that he had multiple DUIs, but the court actually upheld the department there. And I think that's important, even though it's older and it was a sheet of paper, because today most driver licensing transactions happen immediately and electronically. That's under the jurisdiction of FMCSA. They're moving to make everything electronic and automatic as much as possible. And also the American Administration of Motor Vehicle Administrators, which is AMVA. And so most states, the in-state or out-of-state convictions that we're required to share, that happens electronically. When we have questions or concerns about something, we can obviously contact the home state and get more information. But basically what we have is just usually the electronic notification. So I think Steele is an important case for that reason. Blow versus Commissioner of Motor Vehicles, which is the oldest case, was actually a refusal case, and those laws are drastically different than they are now. But a couple of important things from that opinion is, one, operating a motor vehicle on highways is not a natural or unrestricted right, but a privilege. And Blow, that decision also discusses the department's administrative authority separate from criminal proceedings. The majority of the administrative hearings that we have on these cases are pro se, and a lot of individuals say, well, the judge said that they weren't going to suspend my license. How can you be suspending my license now? And it's hard for the average citizen just to understand the difference between criminal law and administrative law, but it is clear that the department has separate administrative authority to carry out these statutory directives separate from the criminal jurisdiction. So more of those administrative actions, and again, none of these lists are completely comprehensive because there's random statutes floating throughout, but we've gone through several of the commercial convictions that would trigger an administrative action. So I just wanted to kind of cover some of the big ones for non-commercial licenses. First, though, I did want to make a correction or a clarification on this slide. The very last subpoint says 3212 52.3 and 3212 52.4 minor alcohol violations. The minor alcohol violations are in 52.4. 52.3 is actually drug-related offenses and isn't tied specifically to age. So I apologize that that isn't really clear on there. But some of the major convictions that will result in a substantive administrative suspension or revocation. For non-commercial license holders are possession or displaying of a canceled, fictitious, or fraudulently altered ID, unlawful use of an ID card, using someone else's ID card, loaning an ID card to someone else, possessing or displaying a canceled, revoked, suspended, fictitious, or fraudulently altered driver's license, permitting unlawful use of a driver's license, displaying another's license, allowing an unauthorized use of a driver's license, unpaid fines, this is traffic fines or any other conviction through UJS, falsifying your driver licensing application, points, which is failing to stop for stop signs, things like that. We don't see a lot of points because speeding is not a point rated violation in South Dakota, but we do have a point system. Habitually reckless or negligent driving, or if you are judged inimical to public safety while driving. Another process that occurs in driver licensing that's not very well understood is the evaluation process, and that is authorized by 32-12-46. There is a form, and it's available on the South Dakota DPS driver licensing website. It's just a one-page form where people can report their concerns that someone else is not physically capable of being a safe driver. There are some stringent requirements on that form. It's signed under penalty of perjury. You can't simply submit a form that says this person's too old to drive safely or this person just isn't very healthy. You have to provide specific examples that you have witnessed as to why you are concerned that the person cannot safely drive. Most frequently, we get these from law enforcement, but occasionally we do get them from the private sector. We review them carefully to make sure that they're not just, somebody's mad at somebody else, or sadly, sometimes individuals are hoping that driver licensing will take the keys away from their loved ones rather than having them do it. So we review those very carefully to make sure the program is acting appropriately. If sufficient concern is raised by the statement, the process that follows is pretty simple. We will provide the driver with a medical and vision statement that has to be filled out by their doctor and an optometrist or ophthalmologist. And we set a 15-day deadline, but if anybody asks for an extension, we're glad to grant it because we know it can be hard to get appointments with those professionals. If the medical statements and the vision statement come back and say they can't meet the statutory threshold to drive safely, it ends there and their license is canceled. If both statements come back, however, and say, nope, they are physically capable of driving safely and they can see to the required statutory level, then we proceed just like if you were getting a license over again. They then have to pass the written knowledge test, and then they take a road test with either a senior examiner or a regional supervisor who are skilled and trained in these reevaluation tests. At any point, they can, if they fail one point, they can continue to repeat it until they pass it. If they have a bad medical and then they can get a good one, that's fine. Then we'll move them on to testing. If they can't pass the written test, they can keep taking it till they do. We do reserve the right in road tests to refuse additional road tests if our staff doesn't feel that they can safely physically be in the car with the driver. So following up then, we touched on implied consent for commercial drivers, but coming back to implied consent for non-commercial drivers, that still exists for the zero tolerance or the underage DUI, which is 0.02. This was just amended this year in the 2019 legislative session because 322311 still actually referred back to 322310. And I apologize, I know it's hard to follow these if you don't know the statutes well. But 322310 was the general, or is still the general implied consent statute that's been on the books for decades. That was the one that says if you drive on the roads in South Dakota, you are considered to have consented to a blood or urine sample to determine whether or not you're under the influence of drugs or alcohol. When the U.S. Supreme Court decided Missouri versus McNeely and said that the dissipation of blood is not per se exigent, automatically thereby creating a warrant requirement exception, our Supreme Court then subsequently decided a couple of cases in which they didn't entirely repeal or rule 3223 unconstitutional, but it did limit it to the extent where it's not really workable and no one relies on that anymore. So the reference that said, well, if you do it under 322310 wasn't really accurate. And we wanted to keep 322311 and 18 as they are because that provides for minors the 180-day period where they get the permit, they can request a hearing and go through that proceeding. So we wanted to make sure that that was all still valid and workable, and the legislature kindly agreed to make that change this year. That was under Senate Bill 11, if anybody wants to go up and look at that. A second legislative thing that happened, and this is actually back to commercial drivers in this legislative session, was an amendment to 3212A36. And again, that's the statute that lists the 7 major offenses that either require a 1-year or a lifetime if you get multiple convictions. And it was subsection 5 of that statute that was amended by Senate Bill 12 this year because it had previously just said refusing a test to determine the level of alcohol in your system. And we clarified drugs or alcohol in the blood or other bodily substances because it didn't match what officers were required to tell individuals under 3212A46, which is the implied consent statute and what officers are required to read to a CDL holder, excuse me, who has refused. So now the statutes match. And also, I apologize, I thought I had a slide in here that talked about driver licensing will issue the implied consent cards. We provide those to all law enforcement throughout the state. If anybody ever wants a copy of those, we can certainly give that to you. But that card just basically mimics 3212A46 and is what officers read either to commercial license holders or the minors who are arrested for zero tolerance DUI. Some other resources regarding CDLs, the Prosecutor's Guide and the Quick Reference Guide, again, these both come from the National District Attorneys Associations, are provided here. And then I just wanted to open it up. That's pretty much what I had. I apologize, I felt like I covered a lot very quickly, but if you have questions, please feel free to share those now. Otherwise, here is my contact information, both my email and the phone number for the department. If you have any questions that you want to talk about one-on-one, I'm delighted to answer those. So Nicole just told me no one has answered any questions. I hope that doesn't mean I put you all to sleep. I guess we can probably just stand by for a couple of minutes. Otherwise, we can sign off and you can get on with your day. All right, well, thank you very much, everyone, for your time. Again, please don't hesitate to reach out to me directly if you have any questions. Thank you and have a good rest of your day.